be a big deal versus what we think they may consider to be a big deal, and sort of can dispel some myths versus realities. I've also worked as a expert witness on multiple court cases as it relates to HIPAA, both for prosecution and defense, and there is a lot of this going on. Unfortunately for us, individuals are learning that they can sue under their state law for reimbursements for federal HIPAA violations. So this is being encouraged by the federal government, and certainly an area that we will be addressing here, because that's one of the big things going in 2016 and beyond. And I will talk about some specifics and some cases I've dealt with and so on and so forth. So let's get started here. We've got a good bit to cover. And I'll just do a quick background, about HIPAA, what it is, how it became what it is. It's known as the Health Insurance Portability Act of 1996, signed into law that year. And interesting enough that when the law came out, it really had nothing to do with securing health records. It was more about health insurance portability, basically meaning if you lost a job, you would have insurance coverage prior to picking up another job, so the federal government didn't have to foot the bill necessarily. Obviously, though, when we think of the word HIPAA, most of us all think about securing protected health information and making protected health information accessible. That's what most of us think about. But there's a lot more to this law. It was bipartisan legislation. Ed Kennedy, Massachusetts, Nancy Kassenbaum from Kansas, bipartisan. So both parties are to blame for all of our headaches with this enigmatic law. Okay, so the acronym, Health Insurance Portability and Accountability Act. It's interesting to note there's something missing in that acronym, Health Insurance Portability and Accountability. So what is missing in that acronym is the words privacy and security. They're not even in the acronym, but by far they present our biggest challenge, because the inherent problem is the federal government tells us what to do, but not how to do it. So the law is extremely gray. Everything's based on reasonable and appropriate due diligence to mitigate risk. Well, what does that mean? How do you quantify risk? It's not the same for all different groups. A tiny little practice somewhere in South Georgia is going to have a different set of policy and procedure than a great big hospital somewhere in Los Angeles. So or an IT company or a billing company. So there's a lot of gray area here in how do we implement this. So real quick, and then I'll get through this history part of this and get into the nitty gritty, but there's 5 titles to this law. Title I, Healthcare Access, Portability, and Renewability. Title II, Preventing Healthcare Fraud and Abuse, Administrative Simplification, and Medical Liability Reform. Now, you'll note in red, Administrative Simplification. The reason that's in red, it's because it's under that subset of Title II where we find the HIPAA privacy rule, the HIPAA security rule, as well as the ICD coding aspects of HIPAA. So under that small little subset, that's basically where all of our headaches reside for a business or a covered entity for the most part. Then there's tax-related health provisions, application and enforcement of group health plan requirements, and revenue offset. The reason I just wanted to let you guys understand there's a lot more to this than what we perceive is HIPAA. So you may wonder why on earth the boy who cried wolf is in this picture. It's because in doing this for so many years, this law sort of reminds me of that old fable. As you remember, the boy would scream, wolf, 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 even though there wasn't really a wolf there, just to get a reaction from the villagers. And then eventually the wolf really did arrive, and then the villagers didn't listen to the boy because he had so many false alarms, and then the wolf eats the sheep and then eats the little boy. So, yes, nursery rhymes are much more violent when we were kids, but nonetheless, that's how this law is to me, because I've been doing this since 2003, and it wasn't being enforced. So what's the point of a law that's not really being enforced? yes, technically it was on the books, but how often did you ever hear of a group getting audited in the past, of groups being fined by the federal government or ever sued, or individuals, for that matter, being fined personally, both criminally and civilly? That it just didn't happen. It was very, very rare. And it might have happened, but there would have had to have been probable cause, like a massive breach of willful neglect, that kind of thing, really, before you would get an audit in the past. Well, unfortunately, that has changed.